Okay, I'm live. I am reading Seizure and Search of Premises, Section 6 of Chapter 3 of Criminal Procedure, Arrest, Search, and Seizure. The cases in this section reflect the basic notion that in the hierarchy of Fourth Amendment values, the privacy and sanctity of home rank very high. Thus, Payton v. New York, in contrast to the Watson case in the last section, holds that a warrant usually is required for an in-premises arrest. Schimmel v. California permits only a limited search of the premises incident to an arrest therein, and Kentucky v. King illustrates that a search warrant is excused only in the event of exigent circumstances. That's important. A warrant is usually required for an in-premises arrest, unless there's exigent circumstances. And Payton v. New York is the next case. 1980, Justice Stevens delivered the opinion of the court. On January 14th of 1970, after 2 days of intensive investigation, New York detectives had assembled evidence sufficient to establish probable cause to believe that Theodore Payton had murdered the manager of a gas station 2 days earlier at about 7:30 a.m. on January 15th. 6 officers went to Payton's apartment in the Bronx intending to arrest him. They had not obtained a warrant. Although light and music emanated from the apartment, there was no response to their knock on the metal door. They summoned emergency assistance and about 30 minutes later used crowbars to break open the door and enter the apartment. No one was there. In plain view, however, was a .30 caliber shell casing that was seized and later admitted into evidence at Payton's murder trial. On March 14th, 1974, Obi Rydick was arrested for the commission of 2 armed robberies that had occurred in 1971. He had been identified by the victims in June of 1973 and January of 1974. The police had learned his address. They did not obtain a warrant for his arrest. At about noon on March 14th, a detective accompanied by 3 other officers knocked on the door of the Queen's house where Rydick was living. When his young son opened the door, they could see Rydick sitting in bed covered by a sheet. They entered the house and placed him under arrest before permitting him to dress. They opened a chest of drawers 2 feet from the bed in search of weapons and found narcotics and related paraphernalia. Rydick was subsequently indicted on narcotics charges in the New York Court of Appeals, in a single opinion, affirmed the convictions of both Payton and Rydick. So, this is the facts for case 2. Facts for case 1. And they're both convicted at trial court and an appeal court affirmed. Before addressing the narrow question presented by these appeals, we put to one side other related problems that are not present today. Although it is arguable that the warrantless entry to effect Payton's arrest might have been justified by exigent circumstances under the New York courts relied on any such justification. The Court of Appeals majority treated both Payton and Rydick's cases as involving routine arrests in which there was ample time to obtain a warrant, and we will do the same. Accordingly, we have no occasion to consider the sort of emergency or dangerous situation described in our cases as exigent circumstances that would justify a warrantless entry into a home for the purposes of either arrest or search. Nor do these cases raise any question concerning the authority of the police without either a search or arrest warrant to enter a third party's home to arrest a suspect. The police broke into Payton's apartment intending to arrest Payton, and they arrested Rydick in his own dwelling. They also note that in neither case is it argued that the police lacked probable cause to believe that the suspect was at home when they entered. Finally, in both cases, we are dealing with entries into homes made without the consent of any occupant. In Payton, the police used crowbars to break down the door, and in Rydick, although his 3-year-old son answered the door, the police entered before Rydick had an opportunity either to object or consent. Okay, so there's no consent, there's no warrant, no consent. And it sounds like the Supreme Court doesn't agree with this. In Payton, the police used crowbars to break down the door, and in Riddick, although his 3-year-old son, right, no consent. So it is the basic principle of Fourth Amendment law that searches and seizures inside a home without a warrant are presumptively unreasonable. That's a basic principle of the rule. Yet it is also well settled that objects such as weapons or contraband found in a public place may be seized by the police without a warrant. The seizure of property in plain view involves no invasion of privacy and is presumptively reasonable, assuming that there is probable cause to associate the property with criminal activity. As the late Judge Leventhal recognized, this distinction has equal force when the seizure of a person is involved. Writing on the constitutional issue now before us for the United States Court of Appeals for the District of Columbia Circuit sitting in Bank, Dorman v. United States, Judge Leventhal first noted the settled rule that warrantless arrests in public places are valid. He immediately recognized, however, that a greater burden is placed on officials who enter a home or dwelling without consent. Freedom from intrusion into the home or dwelling is an archetype of the privacy protection secured by the Fourth Amendment. His analysis of this question then focused on the long-settled premise that, absent exigent circumstances, a warrantless entry to search for weapons or contraband is unconstitutional even when a felony has been committed and there is probable cause to believe that incriminating evidence will be found within. He reasoned that the constitutional protection afforded to the individual's interest in the privacy of his home is equally applicable to a warrantless entry for the purpose of arresting a resident of the house, for it is inherent in such an entry that a search for the suspect may be required before he can be apprehended. Judge Leventhal concluded that an entry to arrest and an entry to search for and to seize property implicate the same interest in preserving the privacy and sanctity of the home and justify the same level of constitutional protection. So Leventhal said that in Dorman v. United States, right? We find this reasoning to be persuasive in accord with the court's Fourth Amendment decision. And in accord, okay. The majority of the New York Court of Appeals, however, suggests that there is a substantial difference in the relative intrusiveness of an entry to search for property and an entry to search for a person. It is true that the area that may be legally searched is broader when executing a search warrant than when executing an arrest warrant in the home. The area, this is important, that legally may be searched is broader, and the search warrant for the person, an arrest warrant. The difference may be more hypothetical than real. However, because the police may need to check the entire premises for safety reasons, sometimes they ignore the restrictions on searches incident to arrest. But the critical point is that any differences in the intrusiveness of entries to search and entries to arrest are merely ones of degree rather than kind. The two intrusions share this fundamental characteristic. the breach of the entrance to the individual's home in terms that apply equally to seizure of property and to seizures of persons. The Fourth Amendment has drawn a firm line at the entrance to the house. Absent exigent circumstances, the threshold may not reasonably be crossed without a warrant. The parties have argued at some length about the practical consequences of a warrant requirement as a precondition to a felony arrest in the home. In the absence of any evidence that effective law enforcement has suffered in those states that already have such a requirement, we are inclined to review such arguments with skepticism. More fundamentally, however, such arguments of policy must give way to a constitutional command that we consider to be unequivocal. Finally, we note the state's suggestion that only a search warrant based on probable cause to believe the suspect is at home at a given time can adequately protect the privacy interests at stake. And since such a warrant requirement is manifestly impractical, there need be no warrant of any kind. We find this ingenious argument unpersuasive. It is true that an arrest warrant requirement may afford less protection than a search warrant requirement, but it will suffice to interpose the magistrate's determination of probable cause between the zealous officer and the citizen. If there is sufficient evidence of a citizen's participation in a felony to persuade a judicial officer that his arrest is justified, it is constitutionally reasonable to require him to open his doors to the officers of the law. Thus, for Fourth Amendment purposes, the arrest warrant founded on probable cause implicitly carries with it the limited authority to enter a dwelling in which the suspect lives when there is reason to believe the suspect is within. So that's the procedure. At this point, Stevens observed the New York argued the reasons supporting the Watson holding require a similar result. In Watson, the court relied on a well-settled common law rule that a warrantless arrest in a public place is valid if the arresting officer had probable cause to believe the suspect is a felon. Clear consensus among the states adhering to the well-settled common law rule. And C, the expression of the judgment of Congress that such an arrest is reasonable. We consider each of those reasons as it applies to the warrantless entry into a home for the purpose of making a routine felony arrest. So that goes with what was said before in the case. This is just a case note, a footnote. There's more that was omitted here. And I will read A, that the relevant common law does not provide the same guidance that was present in Watson, as there is no direct authority supporting forcible entries into a home to make a routine arrest, and the weight of the scholarly opinion is somewhat to the contrary. B, that presently 24 states permit such warrantless entries, 15 prohibit them, and 11 take no position, with a significant decline during the last decade in the number of states permitting warrantless entries for arrest. And C, that no congressional determination that warrantless entries into the home are reasonable has been called to our attention. While the majority then concluded from this that neither history nor the nation's experience lent support in the New York position, the Payton dissenters read essentially the same data as supporting their position. And lastly, in Stiegel versus United States, 1981, police entered Stiegel's home in an effort to find one Lyons, for whom they had an arrest warrant. They did not find Lyons, but they did find drugs in plain view, resulting in Stiegel's arrest and conviction. In reversing the conviction, the court, per Marshall, reasoned that whether the arrest warrant issued in this case adequately safeguarded the interests protected by the Fourth Amendment depends on what the warrant authorized the agents to do. To be sure, the warrant embodied a judicial finding that there was probable cause to believe that Ricky Lyons had committed a felony, and the warrant therefore authorizing the officer to seize Lyons. However, the agents sought to do more than just use the warrant to arrest Lyons in a public place. Instead, they relied on the warrant as a legal authority to enter the home of a third person based on their belief that Ricky Lyons might be a guest there. Regardless of how reasonable this belief might have been, it was never subjected to the detached scrutiny of a judicial officer. Thus, while the warrant in this case may have protected, it sounds bleak. So that's a footnote. I'm going to go back to reading the majority opinion for the Payton case. Although it looks like it just ended. Because no arrest warrant was obtained in either of these cases, the judgments must be reversed. That's the conclusion. And then there is Justice White and the Chief Justice and Justice Rehnquist joined dissenting, which is only 2 pages, or 2.5 pages. Today's decision ignores the carefully crafted restrictions on the common law power of arrest and entry and thereby overestimates the dangers inherent in that power of arrest and thereby, in that practice. At common law, absent exigent circumstances, and entries to arrest could be made only for felony. Even in cases of felony, the officers were required to announce their presence, demand admission, and be refused entry before they were entitled to break doors. Further, it seems generally accepted that entries could be made only during daylight hours. And in my view, the officer entering to arrest must have reasonable grounds to believe not only that the arrestee has committed a crime, but also that the person suspected is present in the house at the time of the entry. These 4 restrictions on home arrest, felony, knock and announce, daytime, and stringent probable cause constitute powerful and complementary protections for the privacy interests associated with the home. The felony requirement guards against abusive or arbitrary enforcement and ensures, so this felony requirement is worth more than the majority thinks, is what is being said. The knock invasions in the home occur only in the case of most serious crimes. The knock and announce and daytime requirement protect individuals against the fear, humiliation, and embarrassment of being aroused from their beds in a state of complete undress. And these requirements allow the arrestee to surrender at his front door, thereby maintaining his dignity and preventing the officers from entering other rooms in the dwelling. The stringent probable cause requirement will help ensure against the possibility that the police would enter when the suspect was not home, and in searching for him, frighten members of the family and ransack parts of the house, seizing items in plain view. In short, these requirements taken together permit an individual suspected of a serious crime to surrender at the front door of his dwelling and thereby avoid most of the humiliation and indignity that the court seems to believe necessarily accompany the house arrest entry. Blackman concurred, but it was omitted. He's bringing up his concurring opinion in the footnote. And to obtain a warrant, therefore, the officers need to show probable cause that the crime has been committed and that the suspect committed it. However, under today's decision, the officers apparently need an extra increment of probable cause when executing an arrest warrant, namely on grounds to believe that the suspect is within the dwelling. I just bring that to the forefront. Back to the dissenting opinion, where they're saying such a front door arrest, in my view, is no more intrusive on personal privacy than the public warrantless arrest, which we found to pass constitutional muster in Watson. All of these limitations on warrantless arrest entries are satisfied on the facts of the present case. The arrests here were for serious felonies, murder and armed robbery, and both occurred during daylight hours. The authorizing statutes require that the police announce their business and demand entry. Neither Payton nor Riddick makes any contention that these statutory requirements were not fulfilled, and it is not argued that the police have no probable cause to believe that both of them were in their dwellings at the time of the entries. Today's decision, therefore, sweeps away any possibility that warrantless home entries might be permitted in some limited situations other than those in which exigent circumstances are present. The court substitutes in one sweeping decision a rigid constitutional rule in place of a common law approach evolved over hundreds of years, which achieved a flexible accommodation between the demands of personal privacy and the legitimate needs of law enforcement. A rule permitting warrantless arrest entries would not pose a danger that officers would use their entry power as a pretext to justify an otherwise invalid warrantless search. A search pursuant to a warrantless arrest entry will rarely, if ever, be as complete as one authority of a search warrant. If the suspect surrenders at the door, the officers may not enter other rooms. Of course, the suspect may flee or hide and may not be home, but the officers cannot anticipate the first two of these possibilities, and the last is unlikely, given the requirement of probable cause to believe that the suspect is at home. Even when officers are justified in searching other rooms, they may seize only items within the arrestee's position, sick, or immediate control, or items in plain view discovered during the course of a search reasonably directed at discovering a hiding suspect. Hence, a warrantless home entry is unlikely to uncover far less evidence than a search conducted under authority of a search warrant. Furthermore, an arrest entry will inevitably tip off the suspects and likely result in destruction or removal of evidence not uncovered during the arrest. I therefore cannot believe that the police would take the risk of losing valuable evidence through a pretextual arrest entry rather than applying to the magistrate for a search warrant. While exaggerating the invasion of personal privacy involved in home arrest, the court fails to account for the danger that its rule will severely hamper effective law enforcement. The policeman on his beat must now make subtle discriminations that perplex even judges in their chambers. As Justice Powell noted, concurring in United States v. Watson, police will sometimes delay making an arrest even after probable cause is established in order to be sure they have enough evidence to convict. Then, if they suddenly have to arrest, they run the risk that the subsequent exigency will not excuse their prior failure to obtain a warrant. This problem cannot effectively be cured by obtaining a warrant as soon as so. They're making case for severely hamper effective law enforcement. As probable cause is established because of the chance that the warrant will go stale before the arrest is made. Further, police officers will often face the difficult task of deciding whether the circumstances are sufficiently exigent to justify their entry to arrest without a warrant. This is a decision that must be made quickly in the most trying of circumstances. If the officers mistakenly decide that the circumstances are exigent, the arrest will be invalid, and any evidence seized incident from the arrest or in plain view will be excluded at trial. On the other hand, if the officers mistakenly determine that exigent circumstances are lacking, they may refrain from making the arrest, thus creating the possibility that a dangerous criminal will escape into the community. The police could reduce the likelihood of escape by staking out all possible exits until the circumstances become clearly exigent or a warrant is obtained. But the costs of such a stakeout seem excessive in the era of rising crime and scarce police resources. The uncertainty inherent in the exigent circumstances determination burdens the judicial system as well. In the case of searches, exigent circumstances are sufficiently unusual. The court has determined that the benefits of a warrant outweigh the burdens imposed, including the burdens on the judicial system. In contrast, arrests recurringly involve exigent circumstances, and the court has heretofore held that a warrant can be dispensed without undue sacrifice in Fourth Amendment values. The situation should be no different with respect to arrests in the home. Under today's decision, whenever the police have made a warrantless home arrest, there will be a possibility of endless litigation with respect to the existence of exigent circumstances, whether it was practicable to get a warrant, whether the suspect was about to flee, and the like. It would be far preferable to adopt a clear and simple rule after knocking and announcing their presence. Police may enter the home to make a daytime arrest without a warrant when there's probable cause to believe that the person to be arrested committed a felony and is present in the house.